Hello, Lucas. Welcome to the OnBlick podcast. First of all, thanks for taking the time out and sharing your thoughts on the new rules that we thought that went away, but seems to have come back with some more amendments. So before I go forward and getting into the podcast, I would like to do a formal introduction so people know who you are, and then we can get into the discussion maybe. So, hello everyone, whoever is listening to this podcast. We are very, very privileged to have Mr. Lucas Garritson. Lucas is a founding partner of Burgos and Garritson Law. With more than a decade of legal experience, he directly manages all employment-based immigration matters for numerous companies and employers. In his experience, Lucas has made a tradition of using effective communication to promote a pathway to combined success. And we really appreciate Lucas for that. As a matter of fact, he's joining our podcast to discuss and bring insight to recent policy changes from the government, along with the input on how to maintain regulatory compliance in today's ever-changing business environment. As a matter of fact, when you say compliance, that literally opens my eyes because Lucas, you've been a valuable resource in designing the key necessities during the development of OnBlick's compliance software, noting what other products were lacking in the market or what other products dangerously expose the end user to huge fines and the loss of brand value. And we truly appreciate that what you have done for OnBlick as well. Your contribution was very valuable. Saying that, Lucas, coming down to the topic, we have three main topics. First of all, we would like to understand the interim final rule. Before we understand the interim final rule, a lot of us are kind of confused about the definition of what a proposed rule is and what an interim final rule is and the kind of impacts that it can have us. Like I said before, we thought, with the Supreme Court decision, this went away, but it seems like it came back again. And we'd like to understand if it's going to stay or if it's going to go away again, or what kind of impacts that it might have, for day-to-day business going forward. And then we would also like to throw some light on the new H-1B lottery and how these interim rules can impact the H-1B lottery as well. And then we have a few question and answers, and our goal is to keep it under an hour. So with that said, I would like to open the floor to you and would love to hear from you as always. Over to you, Lucas.
Thank you for the introduction, Krishna. I really appreciate the opportunity to share this platform and, basically inform all of the listeners and customers of OnBlick about potential changes that might be coming up. And yes, I know, it's been a rough roller coaster year this past year in regards to changes and changes undone and then changes redone. And it's almost like a never ending, badminton or ping pong tournament going back and forth. So to open the topic brought up first, we're going to talk about what the interim final rule is. So the interim final rule was published this past year. One for DOL, which went into effect in October, and then there was one that was potentially that was going to go into effect in December. Now, both of these interim final rules were found to be made in violation of the Administrative Procedures Act by a judge. In fact, two different courts made this decision. And to give our listeners a background of what this means, Congress gives each agency the ability to function and handle certain details that come up within the law. If you can imagine, it would be almost impossible for someone in Congress to write a law that would encompass all the many different things that come up within the function of government. So having said this, under the Administrative Procedures Act, the agencies can go ahead and propose rules and write rules and publish them that go into effect that are based upon what was already put into the code or the law given by Congress. So in doing this, you have to follow certain procedures and certain rules for that rulemaking process. Obviously, what we want is notice, for the public to be informed that a change is going to be coming from the agency. Traditionally, we want, as part of the Administrative Procedures Act, we want notice and comment period from the public to see, what possible actions could have as far as how it affects, if it's a business owner or the public at large or anything in between. And with those comments, they're usually really to the point of saying, like, this might not work for me because X, or this might impact my business because of Y. Based upon those comments, the agency then needs to review all the comments, and you know they'll determine whether or not, and address those comments with their own comments when the rule is published, if it moves forward to that point. So the interim final rule is a rule that when an agency finds that it has a good cause to issue a final rule without first doing the publication, it often characterizes the rule as an interim final rule, and that becomes effective upon the date of publication. So we have to go back to what the definition is. What is good cause? So this past year with these two rules, the good cause was the damage to the American economy that COVID-19 has made. Now, we all know this pandemic started in March of last year, and these rules were published in October and December of this last year. So in both cases, I think the courts had issues saying to the agencies here, both DHS and DOL, is to say, look, this is not fair, because why would you wait if we're in the middle of a pandemic? Why wait 6+ months to issue a rule? Why not issue the rule in March or April? And that was one of the main reasons why, these rules were found to violate the Administrative Procedures Act. Now, you did bring up Supreme Court, and I'm glad you did. So after all this happened, and we had two wonderful cases that saved the day, I guess, for most of our customers here. We have a U.S. Chamber of Commerce case in San Francisco, and we also had a Purdue case, which was joined by the IT Serve Alliance, which was a great help in getting these rules suspended. So basically, we thought this was over and done with. Let's move on with business as usual and get ready for this next year. Basically, there's a Supreme Court decision late last year that DHS and DOL are now reissuing this regulation based as a final rule based on a recent Supreme Court decision, where the court recognized that an interim final rule may satisfy the Administrative Procedures Act, the APA, their requirement of providing notice for the legal basis and substance of a final rule. So we're going back now for the Supreme Court saying that it's okay for the agency to now post the IFR as a final rule, because there's been proper notice before, so it fixes that administrative deficiency. So this case is the Poor Saints Peter and Paul Home versus Pennsylvania, and impacted a different regulatory agency. But the agency, if it's the FCC, FDA, DHS, DOL, any agency, IRS, follows these rulemaking procedures under the Administrative Procedures Act. So if it affects one, that one rule can affect all. And that's what leads us back to today with these new final rules that are being published in regards to DOL and DHS. The DHS rule is titled Strengthening H-1B Non-Immigrant Visa Classifications. The DOL rule is Strengthening Wage Protections for the Temporary and Permanent Employment of Certain Aliens in the United States. And I'll turn it back over to you if you have a question to go ahead and go into detail about these rules.
I think you have put it together very well, Lucas. Now, the way they have put the titles for these rules, it sounds like good news, but inside the rules seems to be the bad news hidden. So really, is it strengthening, the H-1B worker? Is it strengthening the employers? That, I think, like they say, the devil is in the details. So if you can go into the details, of this rule and how, what kind of impact it might have to different employers, especially those that are primarily in the IT consulting and the staffing space, if you could please throw some light.
So going back to the way this rule is, designed to function, is we'll start with the DHS rule. The DHS rule, which includes USCIS under its umbrella, is redefining an employer employee relationship. So we all know this past year, IT server was victorious against USCIS. We had, a wonderful victory where USCIS had rescinded the Neufeld memo and the third-party offsite employment requirements, with all the extra client letters and MSAPOs, statements of work, et cetera, et cetera. And that was a great victory. And I knew immediately after that they were going to try and throw uh, something in our path to help, you know, weigh things back in their favor. But the DHS definition of employer-employee relationship uses similar factors of what we used in the Newfield memo. So some of those factors, like what we saw, would be whether the petitioner uh, supervises the beneficiary, if so, where the supervision takes place. We have where the supervision is not at the petitioner's work site. How does that petitioner maintain supervision? Whether the petitioner has the right to control the work of the beneficiary on a day-to-day basis, whether the petitioner provides the tools or instrumentalities needed for the beneficiary to perform the duties, whether the petitioner hires, pays, and has the ability to fire the beneficiary, evaluates the work product, claims the beneficiary's employee for tax purposes, whether there's any employee benefits, where the beneficiary uses proprietary information of the petitioners in order to perform the duties of employment. So these are some key changes here that it seems similar, but there's a caveat. And we still have where the beneficiary produces an end product that's directly linked to the petitioner's business, right? So in our industry, most of the time, our employees are working on our behalf, but they're working on a product for our client, the end client. And that is where some of these little caveats are coming in, and I'll explain further. After here's one more point: whether the petitioner has the ability to control the manner and means of which the work product of the beneficiary is accomplished. Now, why would USCIS or DHS make these changes? Well, what we're saying is now it's not so much that the petitioner, i.e., the consultancy, has to prove that they have an employer-employee relationship. What they're now expanding on is to say, look, our end client is now also considered to be quote unquote the employer because, hey, the beneficiary is working on end product directly tied to the end client. It's using maybe some of their data that's specific to them. There's a lot of factors that now the government can use to say, look, this is considered, to be an employer-employer relationship. So what does this mean? So the DHS rule was, written, and soon after DOL has adopted that rule into what they define employer-employee relationship. Now, DOL on its own cannot make this designation because Congress, it's outside the scope of what Congress has given that agency to do. So they have to rely on how USCIS defines an employee and an employer in the scope of H-1B employment in this case, right? So when we look at this, when DOL is taking this rule into and adopting it, now they're saying, okay, you have a petitioning company and you're petitioning for your beneficiary employee, and they're working at your client, the end client. So if the end client also could qualify as an employer, now your end client is going to have to file an LCA. They're going to have all the posting notifications. They're going to have to follow all the attestations that are on the LCA. And now they're going to have to also maintain a public access file for that employee. So instead of, USCIS Department of Labor's Wage and Hour Division, instead of them going after smaller businesses, this rule is set up to go after the large Fortune 50 companies, the billion dollars of revenue that utilize the services of H-1B employees. So in essence, what they're trying to do is to circumvent the legal authority given by Congress to define what's an employer, who's not an employer, things like this. And they're going this rule is ultimately just made to attack big tech who hire the services of maybe foreign nationals to help them with their products to help boost the economy. Obviously, I'm sure most all of these Fortune 50 companies would love to hire local talent, but it's we all know this. There's such a shortage when it comes to this. So, the president obviously this is hit from his directive and his focus of saying, "I want to protect American workers," or "Make America Great," or whatever other phrase he wants to use. It's a disruption to our economy, and it could have significant ramifications if this is implemented.
Absolutely. So, Lucas, it's kind of scary, to an extent where you're saying some of the end clients have a reservation of our employees using the laptops or the tools that we give them. They insist that they use the end client laptops because of whatever data privacy reasons and the work product reasons. So in such cases, the end client is providing the tools and instruments. Does that mean that they can also qualify as an employer according to this new interim rule?
Very good point. Yes, I think some of these factors that are listed, and when factors are listed, it's not that we have to, like a checkbox, mark off each point to qualify. There, a factor is something that could be one or all be used to impact, and we look at the totality of the circumstances to make that determination. Now, if you're saying I'm working, number one, I'm working on a project already it's for the incline, it's their proprietary software, their whatever it might be. Number two is using their data, their databases or whatever else it is. And number three, like you said, with data security being number one on all these companies' lists, we're having to. You're probably going to have to use their computers. That's why most of the employees have to go on site. You know, even if you have other protocols in place for working remotely or things like this, there's certain things you can't do or because of a data breach. So these factors are specifically created for these agencies or the people who came up with the rules to give to the agencies know that this is an easy loophole for us to catch these big tech companies and make them pay for utilizing foreign labor. That's really what this is about.
Unbelievable. Now, the question is, for example, as an employer, as a petitioner, we file an LCA with the work location of the end client, and we offer a certain wage level based on the job duties. And then our offered wage is a certain amount. Now, when they go to the client place, so the end client also has to replicate the same LCA, and the timing of the LCA when they file also should be around the same time, and it has to be certified before they start employment for this for our employee.
Yes, for amendments. So if you have an employee who's going to start project in 2 weeks, yes, the LCAs need to be both filed and certified prior to the filing of the I-129 petition amending the stay. Now, if it's just an extension or something like that, that's really not as important because you need to have a certified LCA prior to the filing of the petition itself. But the starting of a new project, yes. So you'd have to coordinate with someone at the end client whenever we do this. You brought up a good point as far as wage levels. So let's say we're here in Dallas, which we are, and we know the software developer application 151132, a level two wage is right at $94,000 per year. Rounded up. If typically that's what most employers will do is they'll look at whatever the appropriate wage level is and they'll pay that rate. And when you're working on C to C and other things like this, the actual bill rate might not be equal to that rate, but we need to pay a higher amount than what the prevailing wage is. So let's say we send you send your employee to one of these large Fortune 50 companies, and they're working as a software developer, and we have properly using OnBlick and some of the tools that's there, we know that this is the SOC code, this is the job level, and this is the prevailing wage. Now, the caveat with this is wage and hour with DOL is looking also to go into this effect by saying, oh, Mr. Fortune 50 company, you have also other people who are software developers and you pay them $115,000 per year. Now, the petitioner for this employee, who's now also considered to be your employee, is making $94,000 per year. How can you show us the delta between those two similar positions? And can you explain to us why you're paying the foreign national much less than what you're paying the actual position at your facility? So that is the loophole where these agencies are looking to attack. And that's really what this is. It's an attack on current business standards as they are, trying to reduce the number of foreign nationals that are employed in the United States. And like I said, it's a very disruptive rule. This is just a 100% an attack on our current business models. I really don't foresee this rule being, fully implemented. That's the good news in all this. But we have to look at the reasoning why this is being done to really understand what the rule means.
Exactly. Very well said. First of all, the intent behind the rule. What is the real intent behind this rule is what we really would like to understand. Now, the next question is, Lucas, the administration is set for a change in a couple of days.
Hmm.
Now, as the administration changes, we see the DHS secretary, everybody changing. I'm assuming that there will be changes at DOL as well. With these changes, is there a possibility that these rules will naturally be rescinded, or we have to challenge these? Somebody has to challenge these rules again, for a favorable outcome. What are your thoughts on that?
That's a good point. I can tell you already that the Biden administration has prepared a memorandum to be issued on the very first day on January 20th, putting a hold on every one of these regulations that were what we call like a midnight regulation, right? So it was done at the last hour of the president's term. He's also going to be looking at immediately rescinding some of these presidential proclamations, orders, whatever it might be, executive orders about other circumstances about maybe how we split families apart at the border, and there's other things that are really inappropriate that have been done over the past 4 years. But everything's going to be tabled for a minimum of 60 days. Okay, so that gives us more or less 2 months for this to clear. Now, a few things can happen during that time. Obviously, these rules are already published. Lawsuits can already be filed. That can be done. Congress can, on its own initiative, vote. Okay, so both the House and the Senate. Now we're all Democrats, even by thin margins. We have Democrats in all houses and the presidency. So uh, under the Congress's oversight, they're able to go ahead and vote on these regulation changes, and they have the ultimate authority to say no, this rule's not correct. It, we vote no to cancel the rule. Then it goes to the Senate. They can do the same thing, and then the president can sign that. Okay, that's one way of doing this too, which is probably more of a practical way of changing most of these regulations because just as much change has been done with the H-1B uh, program. There's been, probably double or triple that with the immigration court, which is under it's not a traditional court in the sense of an impartial judge. Everything with immigration court is uh, through the Department of Justice, which is run by the Attorney General, which works for the President of the United States. So there's a lot of those rules that are also probably going to be rescinded that they put into effect as well. So I would think that there's probably going to be a large list. Now, does that list encompass everything? There's a good chance there might be one or two changes that are not made. So that also, goes back to us saying, maybe there's a chance for us to file a lawsuit as a group to over anything else that's still pending or there. And of course, the it's not really. Um, ethically the best procedure to follow. But President Trump himself set this procedure, here a few years ago, that at the end of Obama's administration, he had the entrepreneurial rule that was published, and pretty much the president, under his direction, the agency ignored the implementation and use of that rule. So, yeah, I can't really see the Joe Biden and the Democratic Party going as far as what he has done, but at the same time, that precedent's kind of been set. So we don't know with how far it will go, but there's a lot of hope that a lot of these changes will be undone.
Right, right. We have to wait for a couple more days or a few more days, to learn more, I guess. But then, like you said, these rules will be tabled for at least 60 days with the new administration taking charge. But then we have this new lottery coming up in March. So that probably would fall within the 60 days. So how do these new prevailing wages lottery system will impact? And I have a few more questions in terms of these prevailing wages and how do they have an impact on the new lottery, on the new H-1B lottery. If you can throw some light on how that would work if this rule has to take effect.
It's a very good question. Another proposed rule that's already in final rule is a change in the random H-1B lottery selection process. And what they're going to change to is DOL wage levels and the SOC codes appropriately assigned to those. So under the regulation, H-1B visa numbers will be allocated according to salary levels, giving priority to those earning the highest salaries in their respective occupations and geographic areas of employment. The final rule will give priority in the H-1B selection process to foreign nationals whose offered salary falls in the highest wage level for their occupation and geographic area. It will not change the order, so the master's and the regular H-1B case selection process will stay the same for the advanced degree. So what we're looking at here is a few factors. Let's say, we file for software developer applications, again, using our example, under the OH and using other ONET data. We know that the standard entry level requirements for this position are going to be a bachelor's degree. That's going to give us our baseline at a wage level 1. So if we have a bachelor's degree with no experience, we're at wage level 1. And if we say the minimum requirements for this position require a master's degree, then we can go to wage level 2. Or if we want to say there's supervisory skills involved, or if there's multiple years of experience, that gets us up to whatever wage level. So we cannot, as petitioners, you cannot just randomly select, oh, this person on a C2C, I can pay them $140K, which is well above the level 4 wage. That qualifies them as level 4 wage, and that's not true. So there's probably going to be more scrutiny with this, and you might run the risk of a case being denied by just randomly selecting the highest wage level. So this system, they're trying to, I guess, affect our OPTs and our CPTs that are here, who've invested a lot of time and money on their masters and maybe been waiting for years to get into the opportunity to even be an H1. And they're trying to make it harder for them to be selected in favor of someone who, in the agency's eyes, might be more experienced or well seasoned from abroad. And so some of these changes are real difficult to kind of grasp as far as like how this can be done fairly, right? So when we have a random selection process, we're looking at it to where we're fair in how we randomly select the person. Everyone has an equal opportunity, so on and so forth. And one of the first challenges you can have under the Administrative Procedures Act would be if something is arbitrary or capricious. So by that definition alone, it means the system's not fair. So, based on this, we really don't have enough information to know for sure how the implementation will be done. We don't even know, using the wage selection or the registration tool, using the using the H-1B registration tool, as we all did last year, we know that we can only list right now the fields for the name, passport information, advanced degree, regular degree, birth date, etc. So I don't know how uh, fast they could implement the changes to the software itself, and I don't know how we can declare what the wage levels are going to be prior to filing an LCA. So these are things that we really don't have details on yet, as far as like, you know, common sense says that USCIS has the ability to shelve the registration tool, and we can go back to the traditional way of filing where we had to print out all the evidence and mail everything in, and then it was randomly selected. So there is a possibility that we could revert back to that process if this rule is used.
Wow. Oh, there are good and bad in that, the lot of time, effort, and the paperwork that we have to collect if you go back to the old process. But again, there is absolutely, or there's a very limited clarity and a lot of speculation on how they would implement this, new interim rule, because they're saying it's based on category, location, and wage level. Now, there are some categories of jobs, that seem to be very highly skilled, like if you say uh, attorneys maybe or doctors maybe, they fall into the higher category, and maybe some kind of an engineer can come way below the value chain that can create a lot of disproportion in terms of who can enter into the US on an H-1B. Will it be all doctors only, or will it be only attorneys, or the computer system analysts, that might be treated as a lower category? Can they enter as well? So there's a lot of speculation, and it might create a challenge. We don't want all software developers only um, in at this point of time. So that's with respect to category that is not being addressed. And the next thing is with respect to wage levels. Now, like you said, we cannot just randomly select a wage level 4 and the job duties not necessarily equating or matching the selection of the wage level. So that creates another challenge and creates loss of opportunity for the OPTs and CPTs who might not have that a leadership role or managerial role opportunities, or roles that they need to have a greater experience or greater education, I guess. So it's unclear and it doesn't seem fair. And I really hope that, like you said, this does not come into effect, because it can create a lot of chaos and confusion, and a lot of qualified people might lose opportunity if this happens. So, so I think you echo to that, saying that this might not happen, but we also have to brace for impact. If at least this year, if this happens.
I would like to add another note of how you're explaining this and explaining it well. There's also been something else that has recently been published as far as SVEP, going back with CVIS and everything else, where they're going to have more oversight now over OPTs itself. So, how are these tools used, not only to impact us with H1s, but what about your employees who are also in OPT or CPT status? How much more regulatory pressure are we going to have? What about training plans? What about uh, your assignments and training and following up and documenting all that? Which again, I'd like to say, OnBlick has done a tremendous job in simplifying that process for employers that allow them to have this documentation that's probably really going to be needed more this year than any other year previously.
Absolutely. Thank you for bringing that up, because that is also very important to our viewers, because with this Form 983 program, the STEM OPT, the oversight, seems to be increasing. Just like we have these USCI site visits, ICE has already started making visits to ensure these training plans are being executed, and the training plans, the training is actually being provided and they're being supervised. So that is going to come back again, it seems like. And like you said, that's maybe going to add a little bit more pressure on the employers, and they have to be properly prepared with the documentations and anything in case ICE knocks the door. Thank you for sharing that, Lucas. Now, last question, Lucas. In one of the statements, President-elect Biden said that he might increase the H-1B quota, right, to maybe
Correct.
about 185,000 or something. And if that is the intention, he wants more talent to come into the country. But then, on the other side, we have a certain interim rule that will prevent, from companies to leverage this talent. Uh, how do you think he's going to bring in more H-1Bs if there are more hurdles to get an H-1B in the first place? So do you think that there will definitely be amendments made to these kind of interim laws, interim rules? Any thoughts on that?
All right, that's a good question, Krishna. I think overall we have to remember that you have to have certain um, oversight, obviously, with the program, but we want the program to function accordingly to what the design or the meaning of the program was designed for. And obviously, the H-1B program was created in the late '80s to help supplement high skilled specialty occupation jobs for shortages in our American workforce, and that's a valuable tool, and it's a tool that's routinely being used. And I do want to, you know, let people know that yes, there is probably going to be a lot of rollback on these provisions under his administration, but at the same time, I think we all saw prior to Trump, which it seems like so long ago. Even under the Obama administration, we saw in starting probably in 2012 on up to when Trump was elected, there were already trends of becoming, more diligent in oversight, more regulations that were where you have to follow up, i.e., matter of semio solutions and amendments required from this immaterial change to employment. Things like this that are just common sense. I think looking back on it as to what why the regulations were changed or what changes were made to the code or whatever. That being said, I think yes, we should have it where there's more access for talent to come into the United States, for more talent to help our businesses we have here. And I also want to bring up another point that we've had a lot of our key H-1B now senior guys here for more than 10, 12 years that have been stuck in a backlog. And, most of our viewers who own consulting firms, we want to make sure that everyone's aware that there could be, possibility for these backlogs are cleared, or maybe a fast tracking to GC. And, what would this mean to business? Because at the end of the day, I don't think it bodes well for anyone to have, so many H1s, just pending. I think that hurts the program more than anything, is because we're not able to have the natural progression of someone going from H1 to GC or whatever else, and they're kind of stuck in a cycle, so to speak, and it's disproportionate and as to what in reality what it really is. As far as a short term uh, employment where a person's been here for less than 6 years, um, those numbers are much less than the people who've been here 8 years, 9 years, 10 years plus, waiting on that GC. So how that's another change I really believe is going to happen this year, and it's been laid out. I'm a member of American Immigration Lawyers Association, and we've put together a lengthy brochure that we shared with the president in regards to changes that need to be addressed. And one of those key provisions and changes is looking at something to help take pressure off of this backlog, because it's just I think now if I filed an I-140 today for someone, the projected wait time is going to be around 70 years, give or take 2 or 3 years for EB2. And so we want to try and have the system work. The way the H-1B system was designed to work was for someone to come here temporarily, perform the highly skilled position, and then under our laws, they have the option. The petitioning employer has the option to sponsor them for their GC, and then that pretty much alleviates that person using the H-1B visa. But due to so much um, usage of these H1s, and the other backlogs that exist, it's kind of caused a situation that no one, foresaw. And that's something that I think the president's really going to sit down and look at, not only the short term fixes as far as like alleviating these final rules that were published and how that's going to impact our business, but what is business going to look like in the next 2 years, 5 years, 10 years?
I think you made some very, very valuable points, Lucas. And you also made a point that a lot of these rules started in the Obama administration itself, like the Simeo solutions and those rules. Now, there is a belief out there the H-1B is becoming more difficult to obtain because of some of the bad actors in the marketplace, that created a negative impression on H-1B is misused or abused the whole program itself. So if you can share some thoughts to our viewers as to how they can really demonstrate compliance and kind of distance themselves from the practices of these bad actors. If you can throw some light there, so that way that could help us, and we can probably close this session and we can come back again with more news. But if you can please share some thoughts on that.
Well, that's a very good point that you brought up, Krishna, and it's something that I think every business person should have in the back of their mind. I mean, is it worthwhile to do something for today and earn an extra dollar rather than invest the time and effort it takes to really harvest and build a business to reap higher rewards in the future? And there's a lot of people that take shortcuts that have really damaged the industry for everyone. There's and I'm not excluding large companies, that we know the large players in what they've done. Um, I think compliance, the best thing we can do to mitigate any damaging um, or I think the one thing we can do to mitigate any damage that has been done from other bad behaviors would be to focus on compliance itself. And when I say that, we know that audits are going to happen. Is your company prepared for that audit? Are you maintaining your public access files? What about your I-9s? All these things with more violations bring more focus to the industry. And we're blessed this time, with technology, to have something that's functional and really basic and easy to use, that takes a lot of the headache and problems out of maintaining these regulatory compliances. Because you have to remember too, most of these regs that were put out for companies to follow don't necessarily mesh with how companies operate today. We're talking about programs that are 25, 30 years old at this point, and what was once simple and easy is now maybe more complex because of technology. So we want to utilize technology and go forward. And I do want to bring up one other point. At the end of the day, all of us are constituents to someone who's run for office and been elected to office and represents us. The best thing you can do is contact your local congressman, your state senators. Let them know how these changes are going to impact your business and how much it's going to hurt the economy. And if we have enough people contacting the right people in Congress, there's a higher chance and an easier path for getting these rescinded rather than having to go fight tooth and nail like we have done in court this past year. And I know IT Server Alliance has really led the way and done wonderful things this year, and it's really been a year that has put them on the map. But we can't rely on courts and judges to always side with us. And at the end of the day, the people who write the laws, if we can influence them and let them know how important this is to our economy, that's going to be the key to really have positive change. And instead of maybe negative changes that are made by people who genuinely believe that this is helping, maybe if the input we have and we share leads to more of a progressive change that both helps people in the industry, consulting companies, but then also is better for the economy, the American economy, the growth, everything else we have here. So it's something that's needed, and I encourage everyone to take part and do their best to help communicate this to their local representatives.
Awesome. Awesome. Very well said, Lucas. I think it's time that every business owner takes that individual responsibility and talk to their representatives about the impacts that their businesses are having on top of the COVID situation already, and how these can demoralize the business and the economy as a whole. I think it's an individual responsibility to protect our own businesses and not just thinking somebody else would do it. Thank you for adding that. It's really, really valuable, and really appreciate the valuable time that you shared with us. I always enjoy listening to you, the depth of knowledge that you have in this area, not just in the law and regulation, but also the focus you always have in compliance. So, everybody gets, a good night's sleep, end of the day. But thanks again for sharing on the OnBlick podcast. We hope that this goes to as many people as possible so they could benefit from your knowledge. Thank you, Lucas. Really appreciate your time once again. You have a wonderful evening now. We'll talk to you soon.
Thank you, Krishna. Thank you, Krishna. We'll talk to you soon.
Bye-bye.